Defense lawyers, what is it like to defend a client who has confessed to you that they're guilty of a despicable crime? Do you still genuinely go out of your way to defend them? I'm a defense lawyer. 95% of my clients are factually guilty. No, it makes absolutely zero difference to our motivation. It's a huge misunderstanding that the justice system determines guilt and innocence. It doesn't. It determines whether the state has enough evidence to lock a human in a cage against their will. So client actually being guilty has nothing to do with that question. Moreover, the vast majority, 90% plus even if you're a very aggressive attorney, and in a plea, the issue is usually that your client is guilty of something for which they have sufficient evidence, but the state has overcharged. You find a reasonable balance based on the strength of the state's evidence. A trial is a broken negotiation and typically only happens if one side is being completely unreasonable, is dumb, or has nothing to lose. Let me address the biggest topic of conversation, overcharging. Couple of points. Yes, it happens all the time. Especially in lower income communities, police and prosecutors start from the very highest thing they could possibly charge. Here's what doesn't happen, which has been brought up a lot in the comments. So let's say a guy steals a pack of gum, the state charges him with foul play, we plead to robbery. Bargaining in a legal case isn't like haggling for a car. There's not a high ball and low ball and we land in the middle, because the defense is supposed to see the evidence so we know what the reasonable charge would be. It's more like this guy. So he steals a pack of gum, state charges robbery and resisting arrest because they allege a scuffle happened during the theft. I look at it and say, okay, the state's got real evidence of the theft and really weak evidence of the scuffle and medium evidence for resisting arrest. So we'll plead to the theft, take off with the robbery, and we haggle over the resisting. If I think maybe they got the robbery, then I advise my client to eat the resisting because it really doesn't add too much and the penalty for robbery is 10 years. If I feel confident that they're doomed on robbery, we hold strong and only plead to theft. So basically, if you have a good attorney, we just bash through the overcharging. Does it move the needle? Yes. Do people cop to charges a bit higher than they should because of the threat of the overcharged crime? Yes. But are people pleading out to absurd things they didn't do because the state is waving bogus charges over their heads? No. Good attorneys don't let that happen. And this is why people should vote for justice positions that claim or prove to be about justice, not just being tough on crime. Story 2. An attorney has an ethical duty to represent their client zealously. That is true whether we know a client is guilty or not. Whether in court or doing pretrial proceedings, we will challenge and evaluate the state's evidence. True whether trying to get a client off all charges, looking to plea, or just figure out a defense strategy. Innocent until proven guilty beyond a reasonable doubt is a heavy burden. It is a higher standard than guilty by clear and convincing evidence and by the preponderance of the evidence. The reason is simple. If the government is going to take a person's liberty or even their life, they had better not be overreaching. The burden is therefore on the prosecution. The defense attorney holds the prosecutor to that. Story 3. What I've gleaned from reading lawyer blogs, it's about defending people's right to a fair trial. Even if someone is totally guilty, prosecutors still overreach and overcharge the perp with plenty of other things they can't prove or haven't even done. The power of the state is incredible and, compared to you, almost unlimited. Defense lawyers have to help make sure that you know your rights and that your rights are defended, or that you at least get something out of giving some of those rights up. Keep in mind that the state will bring hell on you whether you're innocent or guilty, and ideally, defense lawyers will defend everyone's rights equally. One article I read that really stuck with me is from Chasing Truth, Catching Hell. Dear Norm, how do you actually defend those people? Where he discusses someone accused of a heinous crime with no defense whatsoever and answers a question. How do you defend them? What actual steps do you take? Some excerpts. First, I mentally prepare myself for the very real possibility that I will be stuck taking this case to trial. This defendant is the worst of the worst, Mr./Miss District Attorney may say, and he deserves nothing short of a life sentence. Now, this may be true, but it does not relieve me of my ethical obligation to safeguard my client's rights unless he is offered something in exchange for giving them up. Clients hurt themselves most when they feel out of control over their legal situation. Such clients feel railroaded and see their public defender as just another piece of the machine that is pushing them toward a certain outcome. When this happens, the client resists the public defender's advice just for the sake of resisting the process as a whole. I remind the client that the decision to go to trial and the decision to testify are his and his alone, but I also remind him that he has the power to set a more realistic goal for himself. Finally, I document every decision that I make in the case as well as the reasons for it. My client will be convicted, an appellate lawyer will be running a fine-tooth comb through the record of the trial, And if I screwed up something so badly that my representation was constitutionally defective, then appellate counsel can and should argue this to the appellate court. If I can't defend myself, my client's next lawyer will argue that I didn't defend my client either. I highly recommend reading that entire article. Story 4. I had a lawyer. I confessed to my grand theft auto to my lawyer, but I was with 4 others who did it. We spoke of plea options, but he wanted to wait and grant continuances to see how the other cases were built. I ended up getting off like a year and a half later. One guy pleaded guilty and got a safe house. Another got probation, and 2 of us got off completely. I never had to speak in court other than to ask for continuances when he was unable to make it. Then it just got dropped eventually. I was the only one who lawyered up immediately. The guy who got safe house fell for the "we have you on video" with no attorney present. There ended up being no video. If everyone had lawyered up, we probably wouldn't have gotten any time because we took a car for a joyride that had the keys in it, then ditched it somewhere else. Some fellow college students saw us in the vehicle and some guy stole some other guy's girlfriend. And that guy went to the cops with information since we were blabbermouths and told people we stole it. And that's what got us in questioning. This was like 15 years ago when I was in college. Well, now if there's anything I learned from just watching The Wire, it's that you don't ever talk about crimes electronically, and you just don't talk at all when you're being interrogated, not without your lawyer present. Story 5. So I've commented a bunch on this thread but wanted to chime in with an actual answer to the question. What's it like? The same as it is for any other case, regardless of whether there's a confession. It means I now count amongst my acquaintances one more, still alleged, criminal. If all you knew about me was the people I knew, you'd think I kept pretty bad company. How I feel doesn't matter, what I do does, and the approach to somebody who tells you they did it, it is frankly easier than when they tell you they didn't and swear their innocence 50 ways to Sunday. Everybody has a right to plead not guilty, so for me, anytime I approach a case, I start from the top. Was the investigation constitutionally satisfactory? That means, are there issues with the traffic stop, defects in a search warrant, issues with the way a confession was elicited if there was a confession? Thank Christ for clients who know to shut up. Was the lineup correctly done, amongst any number of other questions? Because investigatory protections aren't just technicalities for the sake of a technicality. I had a jurisprudence professor who hated the term technically, and I agree with him. Every technical or procedural rule exists for a substantive reason. If a client is guilty of, say, a possession and there's a weapon in the car and he has a crime, but their car should never, ever have been stopped, the client doesn't deserve a guilty finding because their rights were violated. If we didn't believe that, the entire rule of law system we cherish would fall to pieces. Next question, do the prosecutor's facts match the charges? Sometimes hurting somebody is a big crime. Sometimes it's just a small crime. Sometimes a phone snatching is a robbery, and sometimes it's just interference with a 911 call. Note, not my burden. I have no obligations whatsoever in a criminal trial. One of my favorite judges, when beginning voir dire, asked the jury if they understand that me and my client can sit at counsel table and say literally nothing the entire trial. No cross, no evidence. And if the state's facts do not match every element of the offense beyond a reasonable doubt, they must find my client not guilty. Whether my client has said diddly squat to me is at this stage irrelevant. All that matters is they can prove their case using their evidence, obviously absent any tampering by me or my client. If they can't, then I sleep at night even if my guy is guilty as sin or whatever, because it's not my job to prove him innocent, it's their job to prove him guilty. Next question, and this to me is the last, and unless my client maintains their total innocence, not the most important part of case prep. What evidence, if any, do I have or can I use to undermine their case? Note, again, not prove my client's innocence, undermine their case. Maybe that's evidence to attack the credibility of their witnesses. Maybe it's my client's testimony. Maybe my investigator has uncovered proof positive of innocence. And once I get my evidence, we figure out how to get it all in. 2, do you still go out of your way to defend them? First things first, do I like my $200,000 bar license? Because if I don't go out of my way to run through all of the above steps in every case, I might as well send the pieces of my bar card back to my state licensing authority and find something else to do with my time. Second, defend is a malleable concept. As I said before, technical rules serve substantive purposes. If there's a suppression issue, I chase it. If there's a sufficiency issue, I chase it. Because not only is that the job, it's the interesting part of the job. If you've got evidence of 3 crimes in your house and that's all they've got, and the search of your house was patently illegal, there's 2 conflicting sets of moral justice, and I think OP and I fall on different sides of that. The morally right outcome is either that the integrity of rule of law is preserved or that a criminal goes away. But I don't think you can hold both moral views about it the same case simultaneously. Note aside, I have immense respect for cops, and I've never met one worth a dime that would allow this factual scenario to ever happen. Realistically, though, defend and win don't mean get guilty people found innocent. They mean get the best possible outcome that you and your client can agree on trying to get. Rarely that is, yes, a not guilty finding for an icky criminal. Mostly it's getting the least bad option out of a bad situation. Third, is it a problem, even if I do? Frankly, I get more mad at some non-despicable offenders than a lot of despicable offenders. DUIs angers me off a lot. I don't care if people drink, but I care a lot if they get wasted. I don't have the sense to stay put until they are good to drive. That's effectively thousands of pounds of missile you're putting into gear without sufficient means of controlling it. DUIs are a bit of a menace. People who steal and don't have poverty, substances, or mental illness as an excuse really annoy me. No, I don't think a poor person doesn't deserve a PlayStation. And I mostly don't care about a big corporation's bottom line. But you don't get to take things just because you want it and then act offended when you get called out. There are certain criminal frauds that I find personally quite offensive and some dealers who drive men mad. The one kind of case that I have qualms about winning is the intimate partner mistreating case. Once there's a recanting witness, all bets are off, and I don't love the idea of being involved in a wrongdoer going back to their victim. I don't. I understand it's the complaining witness's often rational choice to recant, but when I win on those grounds, I get uncomfortable because it's the one time I feel like I'm facilitating something really unpleasant. But that doesn't mean I don't do my job as best as I can. And if you're enjoying the video and the story so far, please don't forget to hit that subscribe and like button for more videos just like this. Story 6. If they admit guilt, you have an ethical duty to not make false representations to the court. You have to work your best with the laws you have to make some sort of defense. You can argue that the law is unconstitutional, that he is insane, etc., but you can't lie and say he is innocent. Frequently, I do not ask outright if someone did it or not. You can sort of tell. For example, you can ask, would you be willing to submit to a polygraph test about that? And if they say no, you can be pretty sure they have something to hide, unless they have another reason to not submit to one. However, most of the time, we are not arguing that someone is innocent. We are arguing that the defendant should get a lighter sentence and that there are mitigating factors. There are some people I will never defend because, 1, I hate them too much to zealously defend them, which is a conflict of interest, and 2, if I did zealously defend them and then get them a slap on the wrist, I'd hate myself for it. Story 7. Everyone deserves constitutional protections. It doesn't matter what you've done, the Constitution isn't picky or doesn't choose. Defense lawyers, at least public defenders in the US, focus on that a lot of the time. Despicable criminals can be hard, but if you remember that the Constitution still applies, you can get through. It's a certain level of objective detachment. A defense lawyer makes sure the government isn't steamrolling you and is actually following procedure. Defense lawyers are a bulwark against government overreach, or they should be if they're competent. Also, a lot of people who do despicable crimes, I believe SCOTUS just held that pickpocketing is a despicable crime for sentencing determination. So despicable is a legal term that can, very wildly to say the least, have messed up lives. I know a guy who was severely schizophrenic who thought a woman was an angel robbing him, but it turns out he was mugging her with a weapon and didn't realize it. He thought he was getting his money back from a thief. Public defenders usually try to focus on hooking people up with services and healing that they may not even know about. Also, there are loads of women specifically in prison for despicable crimes who are there because they were defending themselves against their wrongdoer and got sentenced. I personally know a woman who'd been in jail 20 years for ending her wrongdoer. Cynthia Brown is another great example. These stories aren't the exception. People who commit despicable crimes are still people. Not everyone is a raving, heartless monster or Ted Bundy. Those are the exceptions, and even then, it's still not the hardest thing to defend if, at least in the US, you frame it not as letting someone guilty get off. Surprise, most people don't just get off. I really hate it when TV shows are like, he got off on a technicality. Is the Fourth Amendment a technicality? Is that really what you're gonna say right now? So next time someone complains about a technicality getting someone off, I'll just say, oh, you mean like the technicality that is the Constitution? Story 8. You have to. That's the way an adversarial legal system works. Being charged with a crime is a long process. It can end quickly with a plea or drag on to trial for years. You are obligated to present your client the evidence and give them your legal counsel. If it's bad, you tell them it's bad and that they will lose at trial. Some clients still want their trial. If your client wants their trial, then you go to trial. At this point, approaching trial, some clients might have told you that they are guilty. You have to put it furthest from your mind because you are going to have to get up in front of a courtroom and do everything that you possibly can to convince 12 people that your client is innocent. What I have observed in the more overwhelming cases, you try to beat the most extreme charges and you make the state earn every charge. You hold the police accountable to best practices and take them to task when they mess up. You put on every witness you think could possibly help your client. You put your hand on your client's shoulder and you say, "Ladies and gentlemen, my client sits before you, an innocent man." And then you give a hell of a closing argument. You have to do everything possible to prove your client is innocent or the system doesn't work. If you don't do it for the guilty, sooner or later, the innocent will be affected too. I think this is what happened in New Orleans where I work. For decades, defense lawyers worked for the judge, not their clients, so none of them ever fought for their clients. No one held the police accountable to doing a good job, and the courthouse revolved around convicting everyone brought before it, guilty or innocent. Of course, this mostly affected Black Americans because the system was created to replace workers after the Civil War. It's called convict lease. Now, it is very hard to save innocent people from the system. You can't get the prosecutors to even look at the evidence until you force a trial, which can take 2 years or longer. And when you get there, the judge is often arguing the case for the prosecution. Crimes carry extreme penalties, so you often find yourself advising an innocent client that their best chance might be taking time to avoid risking 30 or 40 years or even life. I've worked in this adversarial system for 5 years, and I do not believe it's the best way to do things. There are alternatives that can provide better outcomes for victims and the accused, innocent and guilty alike. Within the system we have, you have to ignore whether you think your client is actually guilty and fight for their innocence no matter what. Story 9. I get this question a lot. First, I usually remind people that my function as a lawyer is materially different from judge or jury and does not require me to assess guilt. If I know someone is guilty, it doesn't change my function. Please know that functional does not mean robotic or consciousless. Second, I indicate that a court of justice is not a court of popular opinion or emotional retaliation. As a society, we have found boundaries appropriate for justice in terms of treatment and punishment under the law. Indeed, impartiality is a core concern for our judges and juries. As to the appropriate boundaries for justice mentioned above, we, as a society, have also agreed that all persons shall be treated equally under the law. Third, and aside from the core principles mentioned above, attorneys' licenses are often regulated by state boards. Among the regulations in nearly every state is the duty for an attorney to zealously advocate for their client. It's worth noting that many states also explicitly reference withdrawing from representation if an attorney has a material disagreement with their client that would impede their ability to represent them. Conclusively, we can see that our legal system is designed to benefit all equally and that fairness and impartiality are core concerns on the sides of both adjudication and representation. It is a special role of criminal defense attorneys to honor the principles of law before their own personal motivations. It's a duty above self kind of thing, in honor of evolved and learned society. In fairness and with respect, the existence of your question is exactly why lawyers must be regulated and why laws must be adjudicated by impartial persons. And one final sentiment, many persons charged with gross offenses believe themselves to be monsters or less worthy. Many of them have been victims themselves in transformation to what they have become. And while choice is always available, you might consider the original position model of ethics as to what person would ever choose to be so despised by society and plagued with behaviors of condemnation. Mercy is meaningful and equal treatment is cognizant that truth and reality are contextual to our immediate existence. And if you agreed or disagreed to any of these stories, here's more for you. YouTube thinks you're going to love this. I'll catch you in that video.